I have actually
distinction.
commented on that particular issue in one of my musings. When the CFPB funding case came out, and they addressed the funding case. Now, you remember, there was a 7-2 opinion with Thomas writing for the majority. I mean, I don't know. They could have decided that one either way on sort of the history element, but they decided it in favor that this was a constitutional appropriation of funds. And there was a footnote in the Alito dissent, which was joined by Gorsuch, who is famous for, kind of being a I don't care if it blows it all up kind of judge. I'm going to live by the Constitution. Who they basically said, yeah, we don't want to talk about the Federal Reserve in a footnote. So, and they said basically that the Federal Reserve is sanctioned by history. Well, sanctioned by, as I said in the musing, sanctioned by history would be a good name for a law school moot court team, but it's not really a good legal argument for a textualist or for an originalist. Sanctioned by history is judge-made law. So I think what that tells me is this Supreme Court is simply not going to go that far in terms of blowing it all up because it's not in the Constitution directly. They have their limits. They think that there is a role for administrative agencies. There's certainly a role for the Fed, and they don't want to be the ones to destroy that to allow a unitary executive to run roughshod on the country.